I know the counts are going to be low today because we got 2 people live right now but it's okay. See if we can get anybody in this thing. We'll wait. It's okay. I don't mind waiting. But you can get them likes up. I know everybody else is in live streams right now, and that's okay. It's all right. It's not a problem with me. I dig it. I get it. Everybody else is in everybody else's live stream right now. But we're about to get into part 3. So if you can get them likes up so we can get a little bit more people in here. Everybody else is in everybody else's live stream right now. I know. I get it. Any conveyance of the modern day. Look it up. All right. Can you come over in the Discord? We got Wise Dome coming up actually in a couple hours. Here in an hour and 45 minutes, Operation Wise Dome is coming on. I got something I wanted to bring y'all real quick. Well, nah, not real quick. I guess this one's going to be our third part. Yeah, we'll just go with it like we're going. So I'm going to dive into it since we got Operation Wise Dome coming up. But this is a reminder that tonight we have Operation Wise Dome, okay? If you don't know about it, the link is in the description. That's going to be 6 p.m. Pacific Standard Time. Lawful, not legal. What's up, Eric? What's up, Lemmy? All right, let's get into it. Now, the private, corporate, state, or municipality policy enforcement officer, aka police officer, duties and limitations of power. Quote, nothing is gained in the argument by calling it police power. Nothing is gained in the argument by calling it police power. Henderson versus City of New York, as well as Nebbia versus New York, 1934. Quote, an officer who acts in violation of the Constitution ceases to represent the government. Unquote. You hear that? All those getting those violations out there. An officer who acts in violation of the Constitution ceases to represent the government. They're not going to back them up. That's why people be out here getting that oath of office. Again, that oath of office is a contract and oath not only to the people, which is the state, but also to God. And that's Brookfield versus or Construction Company versus Stewart. Okay. What's up, Ozzy? What's up, 420 Dragon? What's up, Lynn? What's up, my boy? Whoop. Let's get it. Failure to obey the command of a police officer constitutes a traditional form of breach of the peace. Obviously. However, one cannot be punished for failing to obey the command of an officer if that command is itself violative of the Constitution. Wright versus Georgia. That right there is, sir, I understand that you've given me a command, and I would understand under the traditional circumstances that would be a form of breach of the peace. But obviously, you and I both know that one cannot be punished for failing to obey a command of an officer if that command itself violates the Constitution. Now, are you going to sit here today and continually to ask me to get out of my vehicle, my private conveyance, when you know that there is no probable cause or reasonable articulable suspicion of a crime being committed here and forth now? You know what I'm saying? Like, break it down on them. That an officer or employee of a state, what is a citizen? An employee of a state, what is a resident? An employee of a state or one of its subdivisions is deemed to be acting under color of law as to those deprivations of right committed in the fulfillment of the tasks and obligations assigned to him. Monroe versus Page, get it right. Civil law. 1961, by the way. Another one. Actions by state officers and employees, even if unauthorized or in excess of authority, can be actions under color of law. Thank you. Stringer versus Dilger, 1963. I need that. I need that. That's a good one. Unauthorized. Can and will be when I file mines. Actions under color of law. Quote, the police power of the state must be exercised in subordination to the provisions of the United States Constitution. Buchanan versus Wanley. And Panhandle Eastern Pipeline Co. versus State Highway Commission. Quote, with regard particularly to the U.S. Constitution, it is elementary that a right secured or protected by that document cannot be overthrown or impaired by any state police authority. Unquote. Donnelly versus Union Sewer Pipe Company. LaFerrier versus Grand Trunk Railroad Company. O'Neill versus Providence Amusement Co. This one's beautiful as well. You can't be impaired by any state police authority. You can't. Anything that is secured or protected by that document, that contract that we gave over for all of our servants to abide by, cannot be overthrown or impaired. When officers detained appellant for the purpose of requiring him to identify himself. Now, listen to all of y'all people out there that are coming to me. I get it. I'm getting it every day. I want y'all to know. Every day I'm getting a call in relation to someone saying, I just got off a phone with someone. What's up, Kaya? Shout out Kaya. I just got off the phone with Kaya. She refused to give up her ID, so they took her to jail. Seized her car. Said obstruction. Well, obstruction has to be after the fact of a certain crime. Like, come on, man. That's a warrantless arrest. That's a violation of constitutional rights and due process. Clearly, where was the probable cause for the initial stop in the first place? So again, when officers detained appellant for the purpose of requiring him to identify himself, they performed a seizure of his person. You know when people say custodial arrest? Well, this is where that's coming from, in essence. Because when the officers detained appellant for the purpose of requiring him to identify himself, it doesn't matter what form you are in, whether you're walking, whether you're traveling in your private conveyance, it's irregardless because you're free. They performed a seizure of his person, subject to the requirements of the Fourth Amendment. So when you say, hey, man, I'm just going to invoke all of my rights, including my right to remain silent, and they continue to violate you there afterwards, or the person doesn't utilize the aspect that you've told initially, if there's two cops, and he doesn't protect you and let the other one know, and that other one violates, he's responsible as well. The Fourth Amendment, of course, applies to all seizures of the person, including seizures that involve only a brief detention short of traditional arrest. Whenever a police officer accosts an individual or restrains his freedom to walk away, he has seized that person. And the Fourth Amendment requires that the seizure be reasonable. Mm-mm-mm-mm-mm. But even assuming that purpose, prevention of a crime, is served, you see how they say, but even assuming that purpose of what? Seizure being reasonable. Okay, what is that purpose? Seizure being reasonable. And what must it be in relation to? Prevention of a crime is served to some degree by stopping and identification from an individual without any specific basis for believing he is involved in criminal activity. The guarantees of the Fourth Amendment do not allow it. Move them around, man. Let's get to the real aspects of speaking things into existence, of knowing who we are. That way we cannot be overcome in one presumptions and assumptions that may be brung forth. The application of a code, the application and presumption of a code to detain appellant and require him to identify himself violated the Fourth Amendment because the officers lacked any reasonable suspicion to believe appellant was engaged or had engaged in criminal conduct. Now, this one is so important to me. What's up, Doug? And the reason why I say it's so important to me is the aspect that this goes directly to my situation in Hood River. Directly to it. The application or your presumption of a code to detain the appellant and require him to identify himself violated the Fourth Amendment because the officers lacked any reasonable suspicion to believe that the appellant was actually engaged or had engaged in criminal conduct. No wonder why these people haven't replied. It's past their deadline. What are we about to get a default judgment for me already? I really wanted to argue this thing out. I was really hoping for depositions here, y'all. We'll see. We'll see. Accordingly, appellant may not be punished for refusing to identify himself, and the conviction is reversed. There you go, Kaya. Right there for you, Kaya. Where you at, Kaya? That one's for you. Probable cause, Browns versus Texas. Did you hear that? Accordingly, appellant may not be punished for refusing to identify himself, and the conviction is reversed. Get it back. Reversal. I'm talking about VHS in this thing, man. What? Come on, man. Traffic infractions are not a crime. Thank you. That's why they keep coming to us and being like, sir, for you not to identify or for you to be driving on these roads, it's a crime. No, it's not, bro. People versus battle. What are we talking about? I mean, why not just hit them like that? Why not just hit them like that? No, it's not, bro. People versus battle. It's a crime. No, it's not. People versus battle. We done. There's no more to argue. If you're trying to recite that to them, no, it's not. People versus battle. Just give them that look like, I know what I'm talking. Driving on these roads is a crime. No, it's not. People versus battle. Just give them that look. Just stop. Just, oh, man, you know how that hurt them. That alone, they go, oh, shit, we got one. We got one here, guys. For real. To this end, the Fourth Amendment requires that a seizure must be based on specific objective facts, indicating that society's legitimate interests require the seizure of the particular individual, or that the seizure must be carried out pursuant to the plain embodying explicit neutral limitations on the conduct of individual officers. And what that essentially is bringing home to comprehension is that in the back of all of our law enforcement's minds should be, is my actions bringing forth what the greater society would want? If that constant reflection is in their minds of not only the greater society, but then also a reflection of the great creator within each decision. Now we are really talking about some uplifting things that could possibly take place. A change. Now, the officers of the law in the execution of process are required to know the requirements of the law. And if they mistake, let's check this again. Exactly my point, y'all. The officers of the law in the execution of process are required to know the requirements of the law. And if they mistake them, whether through ignorance or design, and anyone is harmed by their error, they must respond in damages. Roger versus Marshall. Man, these are powerful for civil suits, y'all. Very powerful for civil suits. Quote, it is a general rule that an officer, executive, administrative, quasi-judicial even, y'all, ministerial, or otherwise who acts outside the scope of his jurisdiction and without authorization of law may thereby render himself amenable to personal liability in a civil suit. Cooper versus O'Connell. Well, I know I've had some people talking about suing judges recently. Cooper versus O'Connell. There you go. There it is, Jack. There it is, Kaya. Quote, public officials are not immune from suit when they transcend their lawful authority by invading constitutional rights. You've brought up constitutional rights, huh? You've brought them forth. You've shown it on the record for it to be rebutted. It never gets rebutted, and they try to keep pursuing in the proceedings. Once you've challenged jurisdiction, the want of jurisdiction is not enough. I see why people say don't show up to court. Because public officials are not immune from suit when they transcend their lawful authority by invading constitutional rights in which they took an oath to uphold. Uh-oh. Can we get some public oaths, please? Afflicio versus Woodard. Now we talking. Government and public servants, officers, judges not immune from suit. Immunity fosters neglect and breeds irresponsibility, while liability promotes care and caution, which caution and care is owed by the government to its people. Which caution and care. That means if someone's literally, telling you, hey man, I got, health issues right now. I shouldn't be walking. Let us just go home. Let me not get the car towed. They should be. Immunity fosters neglect and breeds irresponsibility. That qualified immunity that is no longer really existent, while liability promotes care and caution. If we get rid of the qualified immunity, we promote care and caution, which caution and care is owed by the government to its people. Why? Because we pay their salaries. We take care of them to take care of us. But it's not the same. And that's why everything is switching. Rabin versus Rowan, Memorial Hospital, Inc. Government immunity. In Land versus Dollar, 1947, the court noted that when the government entered into a commercial field of activity, it left immunity behind. When it entered into commercial field of activity, it left immunity behind. Well, everything is commercial. Everything is commercial. Now, Brady versus Roosevelt, FHA versus Burr, Kiefer versus RFC in 1939. So the high courts, through their citations of authority, have frequently declared that, quote, where any state proceeds against a private individual in a judicial forum, it is well settled that the state, county, municipality, etc., waives any immunity to counters, cross claims, and complaints by direct or collateral means regarding the matters involved. That one's a big one because it leads me to understand the deeper implications of what collateral they are speaking of. Because if they proceed against me when constitutional violations have already occurred, they waive any immunity to counters. Cross claims, what cross claims all encounters? A lot. We talking about liens? Are we talking about liens when they talk about cross claims? Complaints by direct or collateral means regarding the matters involved. Uh-oh. That one's opening up some fields of thought there, buddy. Luckenbach versus Thekla. Leiders versus Lund. Quote, when enforcing mere statutes, judges of all courts do not act judicially and thus are not protected by qualified or limited immunity. See Owen versus City. So again, if they continue on while constitutional violations have been raised in relation to also coupling with probable cause and jurisdictional aspects, when enforcing mere statutes, judges of all courts do not act judicially and thus are not protected by qualified or limited immunity. And we just learned up here, where any state proceeds against a private individual in a judicial forum, it is well settled that the state, county, municipality, etc., waives any immunity to counters, cross claims, and complaints by direct or collateral means. We getting deep. We getting deep. Very deep. Both versus Terry, but merely act as the extension as an agent for the involved agency, corporation. Agency, corporation, ding, ding, ding. Agency is a corporation, but only in a ministerial way and not a discretionary capacity. Thompson versus Smith. Immunity for judges does not extend to acts which are clearly outside of their jurisdiction. Want of jurisdiction is not enough. Bars versus Heisel. Quote, judges not only can be sued over their official acts, but could be held liable for injunctive and declaratory relief and attorneys' fees. Y'all heard me talking about that injunctive stay pending. Now we talking about liable for injunctive and declaratory relief. Now we getting deep. Grand night, Ralph. We're just in the pre-trial to Operation Wisdom right now. Wisdom, excuse me. Uh-oh. That's not what I meant to do. I meant to do. Yeah. Yeah. Liable for injunctive and declaratory relief. Lazama versus Justice Court. Now, the immunity of judges for acts within their judicial role is beyond cavil. Pearson versus Ray, 1957. There is no common law judicial immunity. There is no common law judicial immunity. Ooh. Ooh. Uh-oh. Pulliam versus Allen. 1970, cited in Lizama versus Justice Court. Quote, judges, members of city council, and police officers, as well as other public officials, may utilize good faith defense of action for damages under 42, 1983. But no public official has absolute immunity from suit under 1871 Civil Rights Statute. But no public official has absolute immunity from suit under the 1871 Civil Rights Statute. Differences. Samuel versus University of Pittsburgh. See also White versus Fleming. Take notice, all government officials, servants, judges, lawyers, clerks, and employees. Ignorance of the law does not excuse misconduct in anyone, least of all in a sworn officer of the law. In regards to McGowan, 1917. Thank you. I'm going to let you now know, public officer, ignorance of the law does not excuse misconduct in anyone, least of all one of the sworn officers of the law. I don't want to have to go get your sworn oath of office, but if we do, it'll be in regards to McGowan in 1917. Oh, man. Oh, I'd love to say that one time. All are presumed to know the law easily. If you don't, you don't. And they're going to run all over you. San Francisco Gas Company versus Brick Weddle, 1882. Do you see now why I tell everybody it's all about knowing? That's all you got to do. You just got to know your rights. That's all it boils down to. It's not about filing paperwork here or filing paperwork there or getting a passport. Matter of fact, let's take one pause for a moment. Take one pause for a moment from this document to get into this actual subject. This is a good segue just for a moment here, y'all. So what we're going to do is we're going to show the aspect of a member of ours within Operation Wisdom. Okay. Situation. What's going down is homie has a passport and he's gone and got the plate and the DOT number like, people teach. And I just want to go through this situation with y'all.
How you doing?
Do you know why I stopped you, bud?
So
one thing is you have a big crack in your windshield right there.
Yeah, I'm getting that fixed.
I don't think that's an accurate license.
It is.
For what?
It's a DOT.
Like a DOT issued you that license plate?
You can look it up.
I've never seen it before.
Like, you
So
can
those are
look it
just
up.
the two reasons. But do you have a license registration?
Is there a crime?
Well, you have a crack in your windshield, and that's not, I'm pretty sure, a state issue license plate.
Yeah, and I'm fixing that.
Okay. Do you have your driver's license on you? Thank you, good sir. Do you have a driver's license?
I have a passport.
Okay. Do you have a driver's license?
I have a passport.
Have you ever been issued a driver's license in the state of Arizona?
I have a passport.
Okay, you're not really answering my question. Do you?
Oh, I have a passport.
Come on out.
Sir, can you search my passport first?
Come on out. Come talk to me back in bed.
My door doesn't open.
Got out of the vehicle, y'all. Literally got out of the car, y'all. Homie got out of the car, y'all. Homie got out the car.
And so, just so you know.
Okay, we're just going to talk back here, man. Right. Stand by that push button, okay?
Homie got a passport, got a DOT number, and got out the car, y'all. He got out. He got out the car, y'all. He got out. Do you see what I'm saying out here? We have to stop this, y'all. We have to get people in line with knowing your rights. It's not about filing anything. I don't care what they tell you. That has nothing to do with it at all. It don't have nothing to do with it. That passport ain't gonna save you. That DOT with those numbers ain't gonna save you. None of it's gonna save you. The only thing that's gonna save you is you knowing who you are. That's how it works. Cold cut clear. There's nothing else that's gonna save you. So you going out here and getting all these contracts.
No, it opens, but
Physically open.
yeah. Well, not fully open.
All right, you want to go stand back right over there? Okay, bud?
Hold on, man. Let me get this. This thing's over here lagging out. I should not be lagging whatsoever. Let me get this to stop. It's ridiculous. We're not gonna have that. We're gonna stop that right now. Get out of here with that lag, man. Hold up. Freeing up some memory, y'all. Come on now. There we go. All right, let's get this out of here with this lag and let's continue on.
I own the car, by the way. And I own the car.
Okay.
And can I get your name and badge number?
I gotta run it by
Can I
name.
get your name and badge number?
After I'm done taking my turn to talk, this is how conversation works. We go both ways, okay? You don't have an accurate license plate on this car. So I have to run it by the VIN so I can see what this car is.
Name and badge number, please. Can you please say it for the camera?
It's right there, bud.
Can you please say it for the camera? Robert Trillo, A178.
A passport don't save you, bro.
One more time?
The address on Last Avenue is still good for you.
That's at least where you can mail anything, yes.
I can mail your citation, get mailed.
Yes, sir.
Stand over here by the wheel.
See, don't save you nothing. It's telling them what to do. Stand there. Passport don't save you. The DOT number don't save you, y'all. I don't know why y'all.
You're gonna get a citation, okay, bud?
May I ask why?
You don't have a valid driver's license. You don't have a registration for your vehicle. You may assume you don't have insurance as well.
See? Having a passport and DOT don't save you, yo. My shit's lagging, bro.
It's a private vehicle.
Weapons
Sounds like you
I'm not that. Honestly, I'm not that at all. Nowhere close to a sovereign citizen.
Give me the same type of rhetoric.
No, I practice the Constitution. I have the Constitution in the back of my car.
That's super good you do, man.
And the Constitution says I have a constitutional right to do what I'm doing in my private vehicle.
That's sovereign citizen.
And if you took an oath to the Constitution,
no more light.
You should help me uphold the Constitution for everybody. This is what I'm doing is going by the Constitution.
Good.
Patients advising that was handled in your bin.
I think it has to be that.
A privately owned vehicle. I have the title to the vehicle.
Now, if you have the title to the vehicle, you actually don't actually own the vehicle. The state has a co-ownership in it, to be honest with you.
190, go ahead, sir.
You said the address on the last was a good mailing address?
Just mailing address, yes.
Not a residential address?
No.
Where do you reside?
Rural free delivery. I live on the land.
Oh, it does have it right there. I just read it.
Fire department, sir, we copy 590.
Phone number?
Yeah.
I'd rather not.
Okay.
192, 98, 27 valid.
They still 5'9"? 159 pounds?
59? Yeah, about that. Probably like 45 maybe.
Losing weight, what?
I've been trying to do intermittent fasting because they say to like heal the body, give yourself out of sugar.
Has been working?
Honestly, yes, because my back has been killing me. I work a lot, so and moving around physically, my back has been hurting. I eat a lot of sugar at once, but then I slowly been reducing my sugar intake. And I'm not gonna lie, if you have like inflammation in your knees or anything, reduce your sugar intake.
All I need to do.
I mean, I won't say it'd be like the cure, but it could help.
I'll give it a try.
Look it up. I always tell people to look it up for themselves. So I feel if you
Now they being
see
cool,
for yourself, like say if you see a doctor or read
the cop that's over here.
a book and it was like, hey, if you like kind of let go of sugar in certain ways, it could reduce this, and this. I feel when you see that for yourself, it's more believable than me.
They just having a good boy conversation. You see what I'm saying? He still gets tickets. He doesn't get his car towed. He doesn't get arrested, but he still gets tickets. So I don't see how that passport is helping anybody. That's what I'd be saying. I don't see how the passport's helping anybody. That's all I'm trying to say in the regard there. Okay, so he still got tickets, and yeah, that's how that goes. So we're going to get back to what we was doing, which is the information. Take due notice, all government officials, servants, judges, everybody. Ignorance of the law does not excuse misconduct in anyone. All are presumed to know the law. It is one of the fundamental maxims of the common law that ignorance of the law excuses no one. No one can be excused from the law. Daniels versus Dean, 1905. Jurisdiction challenged to all at any and all times. Uh-oh. Judge acted in the face of clearly valid statutes or case law expressly depriving him of personal jurisdiction would be liable. Uh-oh. Go get him. Uh-oh. Dykes versus Hoseman, 1984. Man, looking like we're just going to have to start submitting some things with the right case law. Yeesh. In such case, the judge has lost his judicial function, has become a mere private person, and is liable as a trespasser for damages resulting from his unauthorized acts, right? Because, again, we're not proving the aspect of the charges or claims that are being brought forth, because we already know that they are statutory in nature and from colorable law. So if we know that they're from colorable law, they can't be applicable. So if they try to apply them in any aspect when put on notice, in such case, the judge has lost all of his judicial function and has become a mere private person and will be liable as a trespasser for the damages resulting from his unauthorized acts upon you. Do you understand how this goes? I'm starting to see multiple factors of choices now that are beyond that overlay of argument. you're still liable. There's no immunity from common law. There's no immunity from common law. So if we're getting deeper into the principles of saying, I don't need to argue these colorable laws that you got put forth before me as though they are prevalent to the state, which is me, in all of my sovereign capacity, knowing that I am in all highest essence of the spark divine within me and you, then it leads us to understand that knowing that we are the state and sovereign, knowing that we have all authority to act as the king because we took the power from the king into our own, to then dictate and set off or move anything as we see fit if there's no verified harm, complaint, corpus delicti. That's how I'm thinking this bad boy needs to go. And I think I just need a way to apply it one time. Oh, I'm starting to see the light, man. I'm starting to see the light of who I am and who you are, and every being that has a mind to understand and comprehend that they are a spark of creation of the Creator. Because everything is contract. This whole facade of the Matrix is contract and based only on voluntary consent. Man. Yeesh. Pulled a sheesh out on them boys, huh? Man. Let's get it. Where there's no jurisdiction, there is no judge. Oh my geez. Oh my geez. Again, want of jurisdiction. Where are we at? What page? 22 of 24? Okay. Y'all help me remember. We're on page 22 of 24. I need to see want of jurisdiction real quick. Want of. There it goes. Yep, I needed that one. I needed it. Oh, put a W there. Yes, I need that one. Want of. Wait, where's the first one at the end, bro? Want. Where's the other ones? Is it up here? The courts have further declared that want of jurisdiction makes all courts of judges, magistrates, U.S. marshals, sheriffs, local police, all void and not just voidable. Meaning that it just because you want the jurisdiction after I've declared it and you've rebutted nothing, it's not voidable later as though I need to keep going to court to have you rebut it and tell me that it is. It's void, period. Oh, the depths of knowing. The relief of knowing. The relief of knowing. A distinction must be here observed between excess of jurisdiction and the clear absence of all jurisdiction over the subject matter, any authority, subject matter, the statute, violations, constitutional, contract, consent, any verified complaint, corpus delicti, any authority exercised is a usurped authority. And for the exercise of such authority, when the want of jurisdiction is known to the judge, no excuse is permissible. Bradley versus Fisher. No excuse is permissible. Ching chong. I think, sir, ladies and gentlemen, we got us a jackpot. Comprehension at last. Free at last. Oh, at last. We free at last by knowing the knowledge. Let's go. Where was we at? Page 26? I got to get off the search function, though. Let me see. Where we at? 22 is where we was at. Really? We was already at 22? For real? No plan. For real? We got that far? Jurisdiction challenge. We did, man. It's almost over. Man, I like this one. All right. Well, I don't want to see a sidebar right now. Thank you. In such case, where there's no judge. Okay. A distinction must be here observed between excess. Oh, we went over this. Yep. No excuse. We just read that. No excuse is permissible. Yep. At last. But in fact, and in law, such statutes are intended to be applied to those who are here as residents in this state under the Interstate Commerce Clause of the Federal Constitution and the so-called 14th Amendment. But in fact and in law, Such statutes are intended to be applied to those who are here as residents in this state under the Interstate Commerce Clause of the Federal Constitution and the so-called 14th Amendment. But in fact and in law, such statutes are intended to be applied to those who are here as residents in this state corporation under the Interstate Commerce Clause of the Federal Constitution and the so-called 14th Amendment. United States versus United Mine Workers of America, 1947. Oh, let's read what they say. Notice to all whom these presents may come. If I am here at all, I am. So as a man, I am not here as a resident of any state, nation, nor am I of or in this state, nor am I a statutory citizen of the United States in Congress assembled, as all are fictions and creations of government, and therefore, and as such, no statutes apply to me as evidenced in above cases. I am a creature of nature, the creator, and therefore I am a transient foreigner by nature while traveling through life. I am here as a in internere, as a neutral for a short time on my way to the greater beyond, a steward of my father's land and wishes. My documents of in the shire in how do they want you know what, I'm gonna do this real quick. How do they say it? Let's see how they say it. Inere. It won't do the speak. Oh, you're chump change for that one. Well, intenere. That's how I'm gonna say it. That's how it's gonna go. In intenere, standing are recorded for all to see. See Dred Scott versus Sanford in 1857. Justice Curtis. Notice of full faith and credit. I, me, myself, am a state. Withstanding, standing in original jurisdiction. No, as the common law, God's law, a neutral traveling in tenere, demanding all of my rights under God's natural law, recorded in part in the Bible, which laws recognized in U.S. Public Law 97-280 as the Word of God, and all men are admonished to learn and apply it. So I demand anyone and everyone to notice God's law, which are my Maker's laws, and therefore my laws. Article 1 of the Bill of Rights guarantees freedom of religion. The Constitution for the United States of America, Article 4, Section 1, full faith and credit among states. Self-executing and self-governing constitutional provisions, Section 1, full faith and credit shall be given in each state to the public arts, acts, records, and judicial proceedings of every other state. And the Congress may, by general laws, prescribe the manner in which such acts, records, and proceedings shall be proved in the effect thereof. Well, I hope y'all enjoyed that. And I'm about to get off and get ready for Operation Wise Dome because it's in an hour. So the Operation Wise Dome link is in the description. I hope y'all enjoyed that. We'll see you over there tonight. Bye. Wait, how do I end it? It won't go. It's gone. Later.